Good morning. The judgment which I am going to share with you is helpful for young lawyers who are at the first step of court of justice and also for senior advocates because the case seems to be somewhat what is happening. Uh, Here is the case what actually had happened. 138 case was filed. As soon as the other side appeared, an application was filed under section 143A for interim compensation. Then the lower court immediately directed him to deposit 20% of the check amount as interim compensation. 60 days time was there. He sought for further 30 days. That was also granted. Subsequently, he did not comply that. Therefore, the lower court immediately taken the evidence of the complainant and denied cross-examination for the accused and convicted him. Then appeal was also same view, revision was also same view. Then it went up to Supreme Court. Then the Supreme Court has decided the issue. I do not know what is happening in Tamil Nadu. How this had happened before the Karnataka. So Karnataka, this had happened. AAR 2022, Supreme Court 3592. AAR 2022, Supreme Court 3592. So they said if interim compensation not paid, the only recourse available, statutory recourse available to the complainant was to take action as per section 421, the procedure laid down for recovery of fine, which way with this 421 would apply to domestic violence cases and maintenance cases also. And RR recovery is also one of the mode prescribed under 427, 421 CRPC. Now that is the ratio. Noor Muhammad versus Kurram Pasha, not Basha, it is Pasha, Pasha. Noor Muhammad versus Kurram Pasha. Here, this is for our learned advocates, only to remind them, but for young advocates, you go through the judgment. The judgment describes the way how to file complaint, date of check presented, and statutory notice dated, since not filed, so offence was 138. Then immediately on appearance, they immediately filed application under section 143A for interim compensation. 20% was directed. This is what had happened. And this judgment also discussed about what 143A Negotiable Instruments Act directs, and they have discussed one beautiful judgment, Taylor versus Taylor. They say the power is given to do certain thing in a certain way, that must be done in that way only. This is what they say. The magistrate who was directed to record 164 statement in Taylor versus Taylor case, that is 1875. He, instead of regarding his 164 statement the way contemplated under 164 CRPC, he simply recorded a oral statement and given evidence. Therefore, that judgment was pronounced, stating that how you are directed, under what provision you must do it that way. Here, that case was referred because the way of lower courts, including High Court, lower court, appellate court, High Court, trial court, appellate court, revision court committed mistake. by deviating the statutory guidelines. Then again, Ganatara versus Morbi Municipality, 1996 judgment was also discussed about the same, and Commissioner of Income Tax, Mumbai versus Anjum M.H. Gavalia. There also they have given same provisions for all these things, you can understand. Therefore, finally, the problem was the appellate court, the Supreme Court, at the time of admitting the appeal, directed him to deposit some amount. The 3,50,000 was directed to deposit. Then finally, they have also directed to deposit 20% check amount, and the court, that should be in the account of judge, court, and finally at the time of disposal the amount will be dispersed accordingly. So the case was remanded back to trial court, permit him to cross-examine the witness. So this is what some of the senior friends used to share some think about it. I want to know, because I am not conducting 138 cases nor defending, except some juniors, if calls for urgent I will go and teach them. This seems to be very astonishing how, including High Court, has held that denial of cross-examination. Seems to be very pathetic, deviating from democratic principles of conducting a court process. Adi altam partam, against the basic principle of natural justice. The natural theory was also ignored. Whatever it may be, the 3 benches have settled the law, keep it on your file. Then one thing I want to share you. I hope within a few days there is every possibility of the world go back to starting point, because the magnetic waves of sun, which already reached several parts, disturbed the communication apparatus, and today it is again going to reach. This will happen. If this happened, something we may expect. So we should be always ready, because after all, 99% population, including the leaders, all dealing in noble professions, are not honest. Everybody wanted to deprave the rights of their own people, deviating their professional ethics. Therefore, and another aspect, some astonishing information from collegium table circulation was not accepted by judges, collegium judges, the recommendations. So that is in respect of Supreme Court elevations. Because I saw a news, I can't again go through that, a Facebook status. One young advocate is going to be elevated from as a practitioner to the Supreme Court. And if he is elevated, there is a high possibility of his being Chief Justice of India for a long time. I hope whatever may be the ground, we want that sort of transparency, independency of every judge, collegium judges. If some judges are become victim of nepotism, political pressure, or any other pressure, at least the collegium judges, somebody should resist. We want that Alexandrian, Napoleon task, risk in agitating this. Just Abraham Lincoln agitated for the slavery, has sacrificed his life. This I want. I hope at least this only by this act of one or two brave judges. I hope this globe may survive at least some part of globe. Best wishes.